Good afternoon. Okay, let's make sure we have everybody, since there are 10. Which would mean there'd be 7 justices, 2 counsel, and Fran Keneally. So let's just make sure we have all of our justices. Justice Lank, you there?
I'm here.
Justice Gaziano?
Yes.
Justice Lowy?
Yes.
Justice Budd?
Yes.
Justice Cipher?
Yes.
Justice Caff?
Yes.
All right. So why don't we go through the protocol? We have Mr. Barter and Mr. McLean, correct?
Yes, sir. Yes.
So the protocol which we employ is, I think, as Clerk Neely probably told you, we'll give you in the ballpark of 3 minutes to argue without interruption. If you wish to invite questions earlier, you may do so. Then we'll ask questions by seniority. Justice Lang first. I will ask questions last. If any justice has questions after I do, they of course are welcome to ask. You have 15 minutes or until the questions end, whichever comes first, whichever comes last, I should say. And if you are on a landline and have a cell phone, please silence your cell phone. If you are on a speaker, unless it's really quiet, you may want to just pick up the phone. Okay? So, with that, if you call the case, Clerk Keneally?
SJC-11696, Commonwealth v. Laquan, Miller.
Mr. Barter, you may proceed.
Thank you, Your Honor. May it please the Court, I'm John Barter, counsel for Laquan Miller. As you know, this is an appeal under General Laws 278-33E, and I believe the standards of review make a big difference in this case under 33E. The issues in this case arise in 3 broad categories. The first argument focuses on whether the statements of Laquan Miller given to Boston police detectives on July 24th through 25th, 2011, should be suppressed. Laquan had just turned 17 2 weeks prior to the June 14th, 2011 shooting. He was picked up by the police on July 24th, 2011 and brought to the headquarters where Detectives Brown and McLaughlin questioned him. At the motion to suppress, Judge Healy found it was a custodial interrogation, and toward the end of the first interview, Laquan invoked his right to counsel. We're asking this court to independently review the transcripts and the audio-visual tapes to determine whether the statements made in the subsequent interview, the second interview on that day that went from the 24th through the 25th, were a free and voluntary act. We point to 2 legal trends regarding the nature of interrogation. One is whether the now or never technique was employed to create a false urgency. And the second is whether the statements about when counsel would be available was a source of confusion, undermining confidence that the statements were voluntary. As a legal matter, these 2 doctrines find support in Commonwealth versus Novo, Commonwealth versus Thomas, and Commonwealth versus Clark. In pressing these arguments on this record, we're arguing that the law on juvenile interrogation should bend toward justice. What I mean by that is 40 years ago, in Commonwealth versus a juvenile, this court observed that most juveniles do not understand the significance and protective function of their rights under Miranda. More recently, in Commonwealth versus Smith, this court extended the interested adult rule to juveniles up to the age of 18 prospectively, recognizing the importance that a juvenile have an adult present. These cases show a trend toward being protective of the rights of juveniles and recognizing they are not just small adults. They really don't understand the implications of Miranda. In this case, where Laquan did finally request counsel, we're urging this court to conclude that Laquan's rights were not scrupulously honored when he was interviewed for a second time. And number 2, that there should be a new rule or a clearly articulated rule that once a juvenile invokes the right to counsel, no statements made thereafter should be made in the absence of counsel. I see that my time is up, so I will yield.
Okay, thank you.
Thank you.
Any questions, Justice Link?
Hello?
We have you.
Yes, Justice Lynch.
You got me? You hear me?
Yes, you're
Yes.
unmuted.
Ah, there you go. I'm having some trouble understanding why it is you think that he, in fact, invoked the right to counsel and that it was not scrupulously honored. I'm having some trouble because wasn't he not questioned again until afterwards? After he had requested to speak to counsel himself, to the police again himself.
I understand Your Honor's question to have two parts. Number one, whether or not he did invoke counsel, and number two, whether it was scrupulously honored. Is that correct?
Well, I think didn't Judge Healy, he found that he did invoke his right to counsel, so that's not so much my question, but I mean, did he reinitiate his subsequent conversation with the detectives?
Yes, my point here, Your Honor, is that he did speak to another officer and said that he wanted to speak to the detectives again. But the point is that during the first interview, the nature of the questioning led him to believe that this was his last chance, that he really ought to speak to the detectives. He really ought to give them more information. And specifically, this is something that Judge Healy didn't note in his decision. After the right to counsel was invoked, the police did say to him, if there's anything else you want to tell us about, please do. So the last words that he heard from them after he invoked the right to counsel was, please let us know more. And my suggestion, Your Honor, is that when you have a juvenile, it's very difficult for a juvenile to invoke the right to counsel ever or in the first place. And once that right is invoked, I'm arguing that we should suggest that or conclude that the juvenile should not be questioned again until counsel is present, and that there should be more of a hard, fast rule on this topic.
Well, doesn't it depend in part on how we interpret what was said there? I think the Commonwealth is arguing that if you look at this sort of straight on, you're going to see that Detective McLaughlin was inquiring not about whether he wanted to talk with them generally, but about whether the defendant's mother was bringing a lawyer down to the police station, right?
Well, I understand that that's what Mr. McLean is arguing, and I hadn't seen that potential interpretation of it until Mr. McLean raised it. So what I'm suggesting is that the statement can be interpreted in certainly more than one way.
Yeah, so?
And given that the right to counsel should be scrupulously honored, we don't see that standard in very many other places, scrupulous, that any suggestion at all by the police that could be a source of confusion or a source of anxiety for a juvenile who's arrested and Mirandized for the very first time should be given greater weight.
Okay, that's it. I don't have anything else.
Thank you.
Justice Gaziano. Yes, I hear you.
Sorry about that. Can you hear me now? I'm sorry, Chief.
Yes.
Okay, thank you. Let me ask you about the now or never argument. In Novo, in all cases I'm familiar with, the now or never is usually a legally false information. Novo was now or never. You won't get a chance to tell your side of the story to the jury, which of course is false. Here it was now or never. You won't get to tell us the story. We've never extended the now or never to the decision to speak to police officers, correct?
Well, yes, I think that you have, Your Honor. And if you when I jeopardized Novo, I found out that Novo is not good law on one topic, and in that Commonwealth versus Thomas in 2014 addressed a situation where the person under interrogation was not told that he wouldn't get a chance to talk to or to present his defense to the jury, but the suggestion in that case was that he would lose his chance even to speak to the police. So I think that the way that no-go is written, Your Honor, is entirely correct, that it was applying to making a false suggestion about whether the case could be presented to a jury. But I believe that Thomas is pretty clear in coming to a different conclusion and indicating that it need not be only whether or not he could tell the story to the police or to the jury. And in fact, in Thomas, the court pointed out that there would rarely be a case where a defendant couldn't come back and speak to the police again at some point in time if he chose to do so. So he doesn't lose his chance to speak to the police. And that's a point which, on the factual record, if I may, we see that in the second interview, the police officers are saying to Laquan, this is your last chance, because once you get arraigned tomorrow and you have a lawyer, well, we can't just call you up and talk to you some more. There'll be an impediment to our talking to you some more now. So that's why it's all the more that you talk to us now. Almost suggesting that having counsel would be creating almost an interloper who would prevent Laquan from getting the benefit of speaking to the police. And when you're speaking about such a young man who had never had any contact with the police or with the criminal justice system in the past, my suggestion is that the entire now or never, whether it applies to further discussions with the police or with the court, should lead to the conclusion that it was a now or never in this case as well.
Thank you. I'll have to take a closer look at the post-novo cases, and thank you for bringing that to my attention.
Thank you.
No further questions, Chief.
Justice Louis.
Yes, I understand your position that you believe that once a juvenile is asserted a right to remain silent, even if that juvenile initiates the discussion, that evidence should nonetheless be suppressed. But should that not be the case, I want to talk about what happened with the police officer after the initial interview. As I understand it, somebody who knew the juvenile had interacted with him and had no idea what had occurred or why he was under arrest, that the juvenile called her over to the cell and asked to continue the conversation with the police officers. Under our current doctrine, do you agree or disagree that that would be enough to reinitiate the discussion?
Thank you for the question. There are two parts to the answer. Number one, I do believe that a conversation can be reinitiated. In this case, the police officer who was the go-between, shall we say, gave her testimony about how the conversation unfolded, and on a textbook review, I would say that was a reinitiation. So my point is that number one, the things that were said in the first conversation weakened the resolve of the juvenile to keep his mouth shut, and number two, that there should be a new rule, which I know Your Honor's hypothetical is not addressing.
But on your point, there is a little bit of confusion and different views of what happened with the end of the first interview. I think what the Commonwealth might be saying is that, well, the juvenile was calling to see about having an attorney come down right away, and that if since he wasn't speaking, that he would get an attorney when he was arraigned the next day, and you have obviously a different interpretation of that, and Judge Healy doesn't really get into or linger on that issue. But let's take it from your perspective, where the officers, the last thing they say to the juvenile is something along the lines of, let us know if there's anything else you want to talk about. And let's not take the Commonwealth's view of that, being that, about the attorney coming down, but rather your view of it. Would that would be an important fact, but wouldn't that just be an important fact to put into the equation of voluntariness? Because the doctrine's pretty clear on reinitiating. So would your point, with your view of the evidence, from the purpose of my question I'm accepting, the last statement of the police officers would go to the issue of voluntariness, wouldn't it?
Yes, Your Honor, I agree that it would go to the issue of voluntariness. And I highlight that particular phrase after the invocation, but throughout that entire interview, which I believe is 25, 30 minutes long, that first part of the interview, there were other invocations from the police officers to the same effect. This is your chance to sit down and talk to us. This is your one chance to get it off your chest. This is your time to let us know. So I think that Your Honor is entirely correct in pointing out that the final statement does go to the issue of whether or not his statements were free and voluntary, and specifically whether or not his subsequent request to resume the conversation was done freely and voluntarily.
All right. Thank you, Mr. Bowder. Chief, that's all I have.
Mrs. Budd.
Hi, good afternoon. I was wondering whether this new rule that you're looking to have us institute, has it been put in place in any other jurisdiction?
Not to my knowledge, but I hope that's not an impediment. I know this court has invoked rules before other jurisdictions on any number of occasions. I don't know of another jurisdiction that has invoked that rule, but it would be an interesting topic for me to follow up on.
And just so I want to make sure I understand, are you saying that there was no, you're saying based on the circumstances in this case, we can't rely on the fact that he asked to resume the discussions with the police?
Yes, I have a two-pronged argument. Number one is, even without creating a new doctrine, that in looking at the facts of this case and applying the rationale of the now or never cases and the confusion about the availability of counsel cases, that based upon that analysis, it would be appropriate to conclude that it wasn't voluntary. And number two, that a hard and fast rule, whether under Article 12 or common law, would be appropriate going forward and in this case.
Well, I'm actually not talking about the statement. I'm talking about the request to speak to officers. So you're saying that in your view, the request to speak to the officers was not voluntary?
Yes, and that the statements made after reinitiating the conversation were not voluntary, and the reason for that is we have this young, impressionable adult who is being told that he really has to tell them, and he has to tell them now.
Right. No, I understand.
And that undermined or took away the ability of the young man to make a free and voluntary decision.
Okay. Thank you.
Thank you.
Justice Safer.
Thank you, Chief. I do not have any questions.
Justice Kafker.
We already, do factor in age, right? It's not like age is irrelevant. We do. It is one of the factors we consider, right?
Yes.
And the second thing, I just want to make sure I understand when the now or never comment was made. It was in the first interview, right? How long before the first interview concluded?
The entire first interview was only about 25 minutes, so it was not a long interview. So it certainly wasn't a matter of. I'm not saying that these police officers put thumbscrews to this young man or threatened him physically or anything of that nature. What I'm suggesting is that when we already recognize that children very rarely understand what Miranda rights mean, that any comment, however slight, should be enough to show that the statement wasn't voluntarily given, so the now or never, as I pointed out in the brief, came up in a couple of different sentences, a couple of different phrases in the discussion during the first interview, and it also came up in the second interview, but perhaps that's in a different category because it came up later rather than before the initiation.
Is there anything said after? So you say they make the now or never point a second time in the second interview?
They do, in that they tell him very directly. I believe it's close to page. I'm sorry, I can't give you the appendix page number, but I could follow that up with a 16L letter. But they do tell him that once you go to get a lawyer tomorrow, then we won't be able to talk to you anymore. That's why it's really important for you to talk to us right now and give us all the facts and all the details.
Is that the first time or the second time? Because I remember the first time, but I don't remember the second time.
Yes, that did come up in the second time.
Okay. No, I have no further questions. Thank you.
Thank you, Your Honor.
Chief Justice Gantz, I've got only a few questions. How much time passed between his statement that he may want to speak to a lawyer and apparently the officers or detectives saying if something were to change, if there's something we need to know, please make sure that we do, and then you all said, bro, anything else you want to tell us? How much time between those statements and when he spoke to a Detective Kincaid and said, I want to speak to the detectives again?
Well, Detective Kincaid, from what the record tells us, was told that she shouldn't write up a police report about that particular encounter. We don't really have a specific time when she spoke to him in the cell, but the police did, in the intervening time, Laquan was moved from headquarters down to E5, so he was in a different place. So Mr. McLean can correct me if I'm wrong, but I think it was about 2 hours before the police came and started the second set of interviews.
And going to your last point on the acquittal on the firearms charge, am I correct that there was two kinds of ammunition that were found by ballistics with regard to the killing?
Yes, there was both a .45 and either .38 or .357, so two different kinds of ammunition.
So, which would infer two different weapons, of course.
Yeah, it would infer two different weapons for sure. I think it would establish two different weapons. I don't think we even have to infer. But I think it would be too much to infer that it was necessarily two different shooters.
Okay, and he was not the co-joint venturer was tried separately?
The co-joint venturer was not tried. There's nothing in the record that shows nothing in the record that went to the jury showing what happened with respect to the co-joint venturer.
So he was tried alone. Was there evidence about there being somebody else and who that person was, or not?
There was.
Okay, so what are we supposed to do with that? I mean, we don't know whether the jury said, well, we're finding him guilty of murder, so why bother reaching the firearms charge? Well, why do you think that should alter our analysis?
Well, Your Honor, I understand your analysis, and it's a long-standing one, that you don't worry too much about inconsistent verdicts. It could be a matter of compromise. It could be any number of things happen in the black box of the jury room. But in this case, where it was so clear that the jury came out with a question and said, are we talking about the 2 firearms found in that abandoned apartment? And they came back and said, no, we're talking about the 2 firearms used in this shooting. And that's all we're talking about. So the jury was obviously focused on the firearms, and they were focused on the question of whether or not Laquan had them. So my argument here is that I understand the usual inclination supported by case law that inconsistent verdicts are no big deal, but I'd like to put that in contrast with the other long-standing doctrine is that the jury is presumed to have followed the court's instructions. And in this case, the only way that we can observe both of those things is to conclude that the jury determined that he did not have the gun. I understand Mr. McLean's position is different, but this is something that just on a plain logic sense really rings true with my client and members of his family. How could he be the shooter if he didn't have the gun? And it makes a lot of sense, but I understand the countervailing legal doctrines, and I point them out in the brief and recognize that those doctrines exist.
Thank you. I've got no further questions. Any questions from any other justice? And hearing none, Mr. Barter, thank you. And thank you. We'll hear from you, Mr. McLean. I, by the way, misspoke earlier because this is a murder case. You have 20 minutes. Mr. McLean actually went 25, so the error was harmless as to him. But I do mention it to you that you do have 20 minutes or until the questioning ends. So you may proceed, Mr. McLean.
Thank you, sir. Mr. Chief Justice, may it please the Court, Ian McLean on behalf of the Commonwealth. The defendant's convictions here should be affirmed because the defendant's statements were properly admitted into evidence and there was no inconsistent verdict problem created here. As well, this is not a case where it would be appropriate to invoke 33E power. I'd like to start first off by answering a couple of the factual questions that came up as best as I can. Mr. Chief Justice, you asked about the time between the conclusion of the first interview and the initiation of the second interview. First interview began at 8:28 p.m., lasted about 30 minutes, so it concluded shortly before 9 p.m. The second interview began at 11:20 p.m., so 2 hours and 20 minutes. The record doesn't reflect exactly at what time the defendant reached out to that detective that passed by his cell that he knew, so I can't say exactly when it was that he chose to reinitiate communication, but there was 2 hours and 20 minutes, give or take, between the conclusion of the first interview and the initiation of the second interview. Justice Gaziano, you asked a question about where in the initial interview the alleged now or never statement came. That was on Defense Appendix 76 is where that statement occurred. Then the arguably invocation occurred 22 pages later at Defense Appendix page 98. So let's turn to the statements themselves. They were properly admitted. So here what the defendant did was not actually even unequivocally invoke a right to counsel. What he did was ask a question, do I get a lawyer tonight? And I would say that's a far cry from an unequivocal invocation. But even if this court was to determine that was an unequivocal invocation, it was scrupulously honored by the detectives that were interviewing here. Nothing Detective McLaughlin did in response was beyond that which is inherent in custody. He asked no questions that would be reasonably likely to elicit an incriminating response. What he did was answer the defendant's question and then help the defendant contact his family again to see if he'd be able to obtain a lawyer that night. Then he was booked, transported to a new location, booked, and then he reached out to a detective that he saw walking by his cell that he knew that was unrelated to this investigation and chose to reinitiate communications with the detectives. Now, that was a voluntary decision, and the reason we know nothing overbore his will is because you look at what he did there. What he made was a choice to reinitiate in an effort to exculpate himself. At the end of the first interview, he was confronted with two pieces of information the detectives had that contradicted the story he told, that he had been home all night. The detectives told him, we have witnesses placing you on the street, and we have video placing you on the street. So after a period of reflection where he maintained his claim that he was at home, he took that period of reflection through the booking process and then decided I'd better change my story and incorporate those facts to try to maintain my innocence. So I point you to Defense of Appendix page 90 to see those challenges from the detectives at the conclusion of the first interview. And then I'd point you to Defense Appendix 106 to see the first thing that he said when the second interview began. That shows he was making conscious, rational decisions after a period of reflection, trying to exculpate himself. So here, nothing overbore his will. And there was no problem created by the verdicts, rendering them legally inconsistent, so they should be affirmed. And I see my initial 3 minutes has expired, so.
Okay, I'll turn to Justice Link.
I don't have anything.
Justice Gaziano.
Yeah, one question. So after he, I know you quibble with it, but Judge, going by what Judge Healy found, after he invoked, there is some logistical issues that have to be taken care of naturally, but then the police say something like, well, let us know if you want to talk again, and kind of leave that hanging. Was that inappropriate?
No, Your Honor. If you take the statement out of the surrounding context, it could sound like it was inappropriate. But if you read it in the context of what was happening, and what you're talking about is Defense Appendix page 99, what the detective actually said was, all right, you all set, bro? Is there anything else you want to tell us? You all good? Now, if you take that out of context, it could sound problematic, but in the context of what had just happened, where the detective was for the several pages before that, over the transcript, trying to assist the defendant in contacting his family again to see if he was going to be able to bring a private lawyer down that night. And then after that call concluded, the detective said to the defendant, we all set? What did she say? And the defendant's response was, she's on her way. And that's when the detective said, all right, you all set? Is there anything else you want to tell us? You all good? He's trying to determine or ascertain for sure whether or not the defendant is bringing a private lawyer down that night, so the detectives can pass that information on to the officers that are going to book him, so they know to be watching for a defense attorney to show up.
Did Judge Healy make a finding one way or another on that issue?
No, Judge Healy didn't make any specific findings about that that statement.
You'd agree that the best practice when someone invokes is to just say nothing, correct?
Well, not necessarily, Your Honor, because there are things that are going to be communicated.
Well, I mean, nothing attendant to that's not attended to book housekeeping. But here, you're saying, is there anything else you want to tell us that refers to his family situation, his employee situation? One may also, I'm sure, opposing counsel argues, what you want to tell us refers to the crime, correct? So we're left with this kind of ambiguity.
Well, yes, Your Honor, but I would point you back to the Bryant case where the test for scrupulously honoring an invocation is whether the officer knew what he was saying or doing was reasonably likely to elicit an incriminating response. And when you look at this statement here in the context of what was going on, it's not reasonably likely to elicit an incriminating response. What they'd been talking about for several pages of transcript before that was his ability to contact his family and his ability to get a lawyer down there that night. So placed in context, I don't think it creates any problem at all.
I have no further questions. Thank you.
Justice Louis.
Yes, my questions go to the same time frame, and maybe you can give us a context. The comment about you'll get a lawyer later, presumably meaning at the arraignment the next day. The concern is that if he wants a lawyer while he's being interrogated, he has a right to a lawyer right then and there. Is there anything in the context of the first discussion or the second discussion that could be interpreted as giving him, the juvenile, incorrect information about access to a lawyer during interrogation?
No, Your Honor, I don't see anything in the record that would miscommunicate his ability to access a lawyer. So the direct quote, the direct response to the defendant's question, the question was, do I get a lawyer tonight? That's at Appendix 98. Mm-hmm. And the quoted response is, you'll get a lawyer first thing in the morning, unless there is a lawyer you want to call. You have a name and number for a lawyer or something you want to call? So he was providing the information that, yes, you are going to have a lawyer appointed to you first thing in the morning, unless there's somebody that you want to bring down here right now. And that's factually correct. So he wasn't misled in any way, shape, or form about his right to counsel. And then again, I'd point you back to Brian, that what the officer did there in responding to that question was inherent in custody and not reasonably likely to elicit an incriminating response. So the officer was scrupulously honoring an invocation, if there was, in fact, an invocation that occurred here.
Thank you. That's all I have, Chief.
Justice Budd.
Hi. My question is, if we were to find that the statements should have been suppressed, does the defendant win?
No, Your Honor, the defendant would not win there because there's still a significant amount of evidence incriminating him, and I guess he would be suppressing the statements as of the moment he asked the question, do I get a lawyer tonight, at page 98? So we would have had the whole 23 or 24 pages of interview transcript before that occurred, and in that portion of the interview transcript, he told his story and then stuck with it that he had never even left his apartment that night. So we would have witnesses, including his mother and two other witnesses that placed him on the street, two of those witnesses placing a silver gun in his hand, two of those witnesses indicating that he was wearing a black hooded sweatshirt that he was not wearing when he left the apartment 15 minutes beforehand. We would have the witness that was on the second floor of the residence where the homicide occurred that heard gunshots, looked out his window and saw the young male wearing the hooded sweatshirt standing over two bodies, holding what appeared to be a gun, and then traced the beginning of his path up Brookstone Street towards Washington Street where he met someone and then turned onto Brookstone, and that's where the defendant's mother then said she saw the defendant with another juvenile who I won't name, running up the street. And then we have the two separate witnesses that identified the defendant as holding a silver gun and wearing a dark hooded sweatshirt. So that places the defendant holding a gun, wearing the item of clothing, and traces him all the way back to standing over the bodies at the moment that it occurred. And then we also would have the defendant going into his apartment building less than 30 minutes now after the homicide has occurred and telling his father that he knew the person who was murdered. So that's long before that information, the name of the person, would have come out public. So he's acknowledging that he knew the person. We have him matching the description and holding a gun, starting with over the bodies all the way back to his apartment. So there was plenty of evidence here, even without the series of changing stories that he told during the second interview trying to exculpate himself.
Okay, thank you.
Justice Seifer.
I have no questions. Thank you.
Justice Kafker.
The second now or never, what's your understanding about that? And what happened, and does anything happen after that that's of any significance?
No, Your Honor. I don't have the exact transcript page for when it was mentioned in the second interview. I apologize for that. I will send a 16-note letter if my brother doesn't. But my understanding is that, my recollection is that was relatively late in the second interview, and he had already told a few versions of his story regarding the changing story about the stereo equipment before that occurred. So even if you were to say that created a problem during the second interview, we would still have everything, all of the statements that he made up until that problem. So he'd already changed his story multiple times. And that's really the incriminating aspect of the second interview, is when he begins to incorporate the pieces of evidence that the detectives are confronting him with into his story and continuously changes his story, most obviously about the stereo equipment.
That's all I have. Thank you.
Just one question. You spent a fair amount of time, frankly, a surprising amount of time, saying that there was no invocation here. But I'm looking at the transcript at page 98 and 99. So he asked, do I get a lawyer tonight? And then on the next page, he's calling his mother. And his mother says, could you get the lawyer up here, a lawyer? I mean, isn't that absolutely clear that he's seeking a lawyer? He's asking his mother to bring a lawyer that night.
Well, Your Honor, we're only hearing half of that conversation, seeing half of that conversation on the transcript, and it's arguing the alternative really here. I don't think the question of do I get a lawyer tonight rises to the level of an unequivocal invocation. Under Todd, wondering about the advisability of having a lawyer is not an invocation, and under O'Clair, the statement, I'll get a lawyer, not an invocation. So here it's a question, not even a statement. So if you think about the concept of, or compare it to hearsay, a challenge to something as being hearsay, where a question is not a statement. It's so it isn't hearsay. So here a question is not an invocation of a right. But I mean, it's in the alternative argument, Your Honor, that you could affirm on that alternative grounds that he never even invoked.
Right. Well, I understand it's in the alternative, and I know you don't necessarily need it, but when somebody says, do I get a lawyer tonight? And then immediately, well, on the next page, when not much time passed, is asking his mother, could you get a lawyer up here? And they're listening to that part of the conversation. That seems to be an invocation of counsel.
Well, respectfully, Your Honor, I'd say that's ambiguous to me. That's not an unequivocal invocation, which is what the case law is that exists right now. But regardless, I mean, the motion judge that was hearing the motion did find that it was an invocation. So, I mean, you can accept that finding and move right on to whether the detective scrupulously honored it. And I would say under Bryant, he did scrupulously honor it because all that he did was what was inherent in custody.
Okay.
And the other thing I'd like to point out about whether his will was overborne or not, and it just didn't come up in some of the questions, was as this court recently pointed out just on March 17th in matter of a minor, age was factored in there in the calculus for commitment of a juvenile on the basis of substance abuse. Here, age is already part of the calculation under Laquan when you're measuring the voluntariness of a statement. It's one of those factors in the totality of the circumstances. So his juvenile status was considered already in determining whether his will was overborne here by anything that the detectives did over the course of this interview.
I have no further questions. Anybody else have any further questions? Mr. McLean, anything you wish to conclude with?
No, thank you, Your Honor. I appreciate it.
Okay. Hearing that concludes our hearing in this matter. Thank you so much.
Thank you, Your Honor.